I'm going to try and be brief, but a quick background so the committee knows that I know what I'm talking about. I've been doing this for almost 20 years. I've handled hundreds of cases
Go ahead.
in all these systems. I've won close to actually 100 Article 78s. I've won 8 appellate cases, disability pension law. I litigated the Court of Appeals case that interpreted the World Trade Center bill in favor of workers. It's called the Batachi case. I've written extensively on this topic. I, with the help of EMS unions, brought the 78 bill to Senator Golden and Assemblyman Abate, and we're starting to get traction on that. So when I say thank you, I really mean it, because I've been out here, like people like John Field, just trying to do what we can, but sometimes it takes legislation. So I have 5 points just from sitting here, if you'll bear with me, that might take some legislation, because a lot of problems about bringing about change is that some of these funds and systems say that they're controlled by administrative codes, or they're controlled by different, just the rule that they're bound by. So every now and then you have to tweak a rule to bring about change. The first thing I was going to touch on was the presumptive law. The World Trade Center presumptive law, the way it reads, is amazing. And the Court of Appeals in Batachi gave us an amazing decision. It says that if you apply for a WTC disability pension, you get the benefit of the doubt. We're assuming, the doctors have to assume the condition is connected. But here's the rub. If the agency, if it's NYSERS, city or state, NYPD, FDNY, finds no disability, well, then the presumption never comes into play. So the joke amongst us pension lawyers is they could deny a corpse and they're never going to get the presumption. So perhaps legislation, there could be an addition that you bring the presumption to disability also. Let's err on the side of helping the people who are down there, err on the side of the responders. I don't think it's going to open the floodgates. I think it's just going to make denying people finding no disability harder. So that would be my first suggestion, is add to the legislation that the benefit, that the presumption extends to disability. Let the medical board disprove the disability, because right now I'm seeing some cases, and you've heard some cases, where disability seems obvious, but it's not. My second one, in terms of, again, this might be legislation, and many people up here have talked about the courts and their decisions that no agency is bound by another. So NYSERS isn't bound by Social Security. NYSERS, state, FDNY, NYPD, all the systems aren't bound by comp, aren't bound by outside agencies, aren't bound by the employers. So while it's a piece of evidence, their medical boards are able to say, well, it's just one piece of evidence. Perhaps enact some type of legislation, some type of rule that says agencies like Social Security, like comp, like employer decisions must be given great deference. And people hate lawyers because it's all about words and wording and terms, so you got to pick the right words. And I know especially getting things through committee can be difficult with words, but if you find the right language, just that it's not given the same weight as somebody's general care doctor. And I get it. I've been at NYSERS, and I don't want to disparage anyone, and we all know that everybody's not on the level. I've seen people put knee braces on. I've seen people with canes that have tags on them. But in these 9/11 cases, in the case of uniform responders, in my experience, the vast majority are extremely legitimate. So now if you have Social Security, federal government saying you're unfit for any job in the national economy, you can't be a pencil pusher, you can't be a drawbridge operator, how can an agency turn around and say, yeah, well, it's a different standard? Yeah, it's a higher standard. You're saying you can't do what I do, but how can you, right, how can you go tackle an inmate? How can you go carry a person? How can you run into a building? So that's crazy. So maybe give that a little more benefit than an average private doctor, because that's the agency's response, is that, well, private doctors advocate for their patient. They're always going to say you're sick. In some cases it might be true, but if Social Security, they have no skin in the game, they're giving you money. Same with comp. Comp is paying out. If you come in with a comp decision that gives an absolute loss of use of a body part or a total disability finding, that I think should be given more weight. And if you're going to reject that, compel the medical boards to explain why. The other is with the employee doctors. If BHS is taking somebody out of service, they're doing it for a reason. Yes, I get it. They have to err on the side of caution. But still, these legal limbos are created when you can't go back to full duty, there's no light duty spot, or your job doesn't have light duty, and then your pension agency turns around and says, well, we see what comp said, we see what your employer said, we see what SSD said, but we're not bound by any of them. So we're going to make our own decision. I don't think binding agencies to other agencies is ever going to happen, but at least if you're able to, compel that the other agency decisions be given great deference. And again, the wording is not easy, but whatever wording you can come up with, I think that'll level the playing field a bit. The next one I was going to talk about is the WTC applications and death cases. I don't want to step on anyone's toes, but I think just a little clarification, my understanding, and I've done a lot of these. If someone dies of a WTC condition, they can then go back and apply for WTC line of duty death benefits under the WTC law. The problem is, though, if they're out on 3/4, even if it's WTC 3/4, even if it's cancer, or if it's fatigue, or if it's sinusitis, whatever it is, that could kill them, and the benefits do stop, and the family has to come back and put the application in. So hopefully, God willing, they'll get approved, and there will be a line of duty death benefit paid out. But what happens in that gap? To me, I would suggest some type of carryover. If someone is a responder and they're out on a pension, carry that over for 6 months, carry it over for a year, carry over the medical benefits, give the family time to grieve, and then put in the WTC death benefits application. And I would suggest, and again, I know NYSERS people are overworked, underpaid, understaffed, but Social Security has taken the step of streamlining WTC cases. Why can't there be a WTC processing unit? People are sick, people are dying, especially with the death cases. Again, carry the benefits over 6 months or a year and regulate that these have to be processed in 3 months. Families need a decision. But while they're waiting on that decision, make the agency carry over the benefits so no one is left in the lurch. What was being discussed before about not taking the maximum, with the death benefits on a regular application, if you take less than 3/4, yes, your families get, it carries over. But then you're losing out on all this money now. But they're scared of that gap. No one wants that gap. So they're compromising their financial means while they're alive. It's heroic what they're doing, but it shouldn't have to be. There should be a safety measure. There should be a gap, and I don't think it's that hard to implement. Just 2 more. The last one was the doctors. I couldn't agree more. It's been said so many times, so many ways. If it were me, you need new ones. You need more of them, and I think finding them and appointing them is the key. I don't know if this committee could somehow create a position, and I don't want it, so I'm not saying it for that reason, but a liaison of sorts that oversees that process, and I don't know how hard it is to create committees, but someone who is outside the agency, who NYSERS is going to say that the unions are going to hire union-friendly doctors. Unions are going to say that they're going to hire company-friendly doctors. So have some type of outside committee or outside liaison hire a pool of these doctors. If you only had to show up once or twice a month for a couple hours, and you could put on your letterhead or your CV that you are a medical board doctor for such and such pension system, you would have people come. Not even for tremendous compensation, just for the advertising, and you'd get good outside impartial doctors to see these cases. It shouldn't be the same names and the same faces, and I'm not going to say the names on camera, but I know when someone comes in and they're complaining about a state system IME or about a particular NYSERS doctor or 2 or 3, I know who it's going to be. And those people are in place year after year. They keep these jobs, they keep being able to hold themselves out, and they keep hurting people. Sure.
You put 5-year maximum for these people.
Sure.
That's it. They can't be in there for 20 years. They're part of the problem.
Yeah.
Or talk about term limits.
Or hear complaints. If someone has a complaint and it's valid, listen, people are going to gripe if they get denied, but if there's enough complaints and there's enough validity and there is a committee and there is a liaison, maybe then there'll be more of a fair playing field. And again, I get it. I am not here to say everybody should get approved. I know there's economics, and I know there's people who aren't completely legitimate, but it seems to me that some of these doctors, when they're there too long, become jaded. And it becomes adversarial, because maybe they've seen a few too many that they didn't think were legit. And again, uniform responders, 9/11 responders, there should be a greater level of respect, I feel, and I don't want to disparage any job title, but what I've seen is that there's this aggressive mentality that because they saw one person on the cover of the New York Post, everyone must be on the take or looking for something they don't deserve. And I don't think that's warranted. And I think with a greater pool and more turnover and the doctors being appointed by people from both sides, I think you'd get more fair decisions.
It's the way they handle arbitrators for the Office of Collective Bargaining.
Yeah.
He has to agree. So if you have an arbitrator who routinely rules for the unions, guess what? The city's never going to agree to their reappointment. The same thing in reverse. So you could take the same concept for the medical boards that we apply at the Office of Collective Bargaining on arbitrators.
Yeah. And so, listen, no one's ever going to be completely happy, but at least you're getting a pool where someone is not just, I can't believe it's this person again. Why is it this person again? Really quickly, I don't do as many, but the state retirement system cases, you have to change their appeal process. The way they do it is if you have the applicant, and they're the only one with the internal appeal process, but the applicant testify, and then they want their doctor to testify, and then the state doctor is going to testify, and then they have another. They wait till the end of one being completed to schedule the next. And it could be 4 and 6 and 8 months between scheduling. So what happens, if you want to call 2 of your own doctors and you want to testify, which you're going to testify in your own hearing, it's literally 2 to 3 to 4 years till you get a decision because they only have 11 doctors and they're going to wait for you to be done, get the transcript, then schedule Dr. So-and-so, and that's 9 months since you testified, then 9 months from the next, 9 months from the next. To have a hearing process that takes 3 years to complete is shocking. But when they said 11, I was actually shocked. I thought it was going to be 25.
11 examiners.
No,
I actually have more people who work for me.
And even if you want to have 11, the fact that you know 4 people are testifying, 4 people are going to testify, schedule all 4 in succession. I mean, there has to be some rule. Just schedule them. Say, point 1, 2, 3, 4. This will be over in 6 months. To wait to after everyone schedule again, commonly 2 to 3 to 4 years. The director said that, yeah, it's sort of a problem, 2 to 3 years. That's a huge problem. People are losing their houses. People are dying. So that's an easy fix. That's with the state system. And my last one is just, and everyone's touched on it, and I know we're going to talk about it more, Senator Gold, and I appreciate you and Robin's help, but this 78 law to me, I want to have this on the record because this was sort of just something I came up with and you ran with. What it's going to do is just give a safety net to municipal workers. It's going to level the playing field. People here today have spoken about we don't even want to go down that route. And listen, I'm an attorney, I get paid for this, I get it, it's self-serving. But I've also won close to 100 of these 78s. So they can be won. But the problem is the judge's hands are tied. If I come in with a spinal fusion, EMT denied, and the judge is like, what is this? You're not carrying my mother down the steps. This is just so clear and obvious. Give them the power that a comp judge has, that a Social Security judge has, and let them, if they're convinced, if it's clear and obvious, if it's an egregious denial, again, it's all in the language. I know that. I'm learning as I go about the legislative process. It's all in the language because there's going to be pushback. But make it so the opposition understands this is just a safety net. It's not going to open the floodgates. The power to remand is still there. All this is going to do is prevent the really scratch-your-head denials from having to go through that endless cycle of kickback, kickback, kickback court. And it's also going to encourage people who are told by their attorneys, well, if I spend the money and I go to court, what can the judge do? Oh, all he can do is send it back. So why am I going to go to court? So now, if with this power, with it being a safety net, technically, and this is the same way the 9/11 law financially got discussed, no one who doesn't deserve a pension is going to get one. So fiscally, it's not going to have any effect. It's only going to be the deserving people who somehow were wronged at the medical board that the judge felt so confident that they're going to award it. And it's not going to be every case. And if the medical boards are cleaned up and they do the right thing, it's just going to sit in mothballs. So I think that's a really practical solution that can level the playing field also. That's all I got. Thank you.
Thank you.
Yeah.
Good suggestions.
You guys are